May I Lordship, Lordship, I beg to mention item number 4. Here I have to file a affidavit, Your Honor. It's
Yes.
almost ready, but yet not yet filed, Your Honor.
Mr.
B type audio.
B so and so, learned counsel for the opposite party.
No, Your Honor, it's appellant.
4, isn't it?
Appellant.
Item number 4.
4.
You have to file a rejoinder.
No, Your Honor. Affidavit explaining 56 days condemnation.
Additional affidavit.
Yes, Your Honor.
Okay. So you are going to file an additional affidavit
Yes, Your Honor.
because in your first affidavit you did not explain.
No, Your Honor.
Then why did you pray for condonation if you did not explain?
Yes, Your Honor. I have been directed to
Okay,
explain.
direct to file. Okay,
Yes.
Mr. So and so, learned counsel for the applicant / appellant has prayed for further time to file his additional affidavit. In view of the above list, when will you be ready?
Your Honor, it's ready within 2 weeks.
Within?
2 weeks, Your Honor.
If it's ready, you can file it tomorrow.
It's tomorrow, but the leading counsel is out of station, Your Honor.
Okay.
That's why.
List after 2 weeks.
2 weeks, Your Honor. Obliged.
May your lordship. Lordship, here I'm appearing for private respondent number 5, your lordship. We have not been furnished with a copy of IA as well as writ appeal, your lordship.
Shiv, I am furnishing now, Lordship. That it is. I thought that earlier it was already furnished.
Okay, Mr.
I am AK Singh. Lordship.
AK Singh, learned counsel for the applicant / appellant is present along with Miss
Enanju,
Nanju, learned counsel for respondent number 5.
5, private respondent number 5.
The learned counsel for respondent number 5 submits that she has not been furnished a copy of the IA along with the writ appeal.
I have furnished now.
Okay.
Lordship.
Accordingly, Mr. AK Singh, learned counsel for the applicant / appellant submits that he has now furnished the copies, required necessary copies. In view of the above list after 2 weeks.
Yes, Lordship.
Obliged.
I appear for the statement in this matter.
None appeared for the none appeared for the petition on call, while Mr. Chowdhury, learned AG appears on behalf of the state respondents. In view of the above list after 2 weeks.
Can I pray for a date since I'll have to?
Okay,
come
okay.
to Guwahati? Can it be on 17th of May?
Okay, in view of the above, as prayed for, list on 17th May.
Well, then- Are you ready?
Madam, this is a contempt case, but one of the counsel, it appears, Brother Parme is not here today on legs. Which contender?
Wait, let's see. What is the stage? So you're supposed to, the respondents are supposed to show their, file their show cause notice, isn't it? Have you done the needful?
Well, the case in nutshell is this, the petitioners, they are a grade for employees. working in the power department as a workers labor. And then they have worked over 10 to 20 years. And some of them have worked a little above 10 years. And then they were not regularized. Thereafter, first they assailed the writ petition, and in the writ petition was interfered by this honorable division bench. And thereafter, direction was issued to comply with the order of this honorable court. But then after 7 months also, my lord, this was not complied with.
So are the parties represented, all the
No, but one of the council represents.
counsel for respondent number? Who are you representing?
I don't know, his senior must not have briefed him properly. Power
Okay.
department.
Mr. T.T. Tara, learned counsel for the petitioner is present, along with,
I'm on behalf of El Parme for Power Department.
okay, while Mr. Your,
On behalf of El Parme.
okay, while mention is made on behalf of El Pame, learned counsel for respondent number?
For Power Department, Madam, I
No, this is the contempt petition. So they are engaged as an individual.
No,
this thing.
give me a moment. I
Uh-huh.
shall try to assist the court.
Not power
Huh?
department.
Without
These are
saying.
against individuals. Contempt petition. Respondent number one, most probably, El Parme. Parme. Is it?
Culling time, Lord, that's one.
Yes.
Container number one.
Mention is made on behalf of Mr. El Parme, learned counsel for respondent number one. What? For adjournment of the matter, since the learned counsel is not able to appear today. Anyone else appearing? Mr.
Yes,
S. Tapin appears on behalf of respondents number 227. In view of the above submission, this is matter after 2 weeks.
Day after tomorrow.
When do you want? Thereafter also, my lord, this is very old case and then involving the poor workers.
Okay, list in the next week.
Right. Next week, my lord. Grateful.
तो सिर्फ जैसे delay of 322 days हो.
Yes,
Notice the issues.
okay. we should, Mr.
S Tapin.
S.
S Tapin.
Tapin, Mr. S. Tapin, learned counsel for the applicant. This is a application filed under section 5 of the Indian Limitation Act, 1963, for condonation of delay of 322 days in filing the appeal against the judgment and order dated 09/05/2023, passed in. Now, this is an IA.
Hello, sir.
If it is an IA, can it be a judgment and order, or should it be an order arising out of some judgment maybe?
So सिर्फ by this IL also, the order passed in IL also. The judgment itself has been modified.
So 09/05/20 passed in. No, when it is a IA, I have not looked into the file, it should be an order. How can it be a judgment and order in an IA? Let's see.
I think this, yes, clerical.
Okay, so it should be an order.
No.
Is it? What?
It may be mentioned.
It's an order. This is then if it's an appeal against an order. Okay, let's see. It's an order, not
No.
a judgment. Okay, order. Dated so and so in IA within brackets capital C, number 79 within brackets capital AP 2023 within brackets, okay, 2023 person. Okay. Notice is to be issued to the opposite party through registered post with AD within 3 days,
Yes.
returnable by 2 weeks.
Yes.
List after 2 weeks.
All right.
Yes,
I'm
are we
the
ready for
amicus in-
hearing?
Yes, I am the amicus in this case.
Hmm.
Applicant is represented by, he is the PP in this case. Applicant remains absent.
So this is regarding under section, appeal is under against an or judgment.
Yes, 307 and 326.
Oh,
That would, arms act.
I'm sorry.
arm's side.
So we can go ahead,
Yes.
isn't it? Who is required?
Applicant is not present.
You are for the,
I am the amicus.
so you're appearing for the appellant, isn't it?
No.
Oh,
For victim.
okay. Okay. None appear for the appellant on call, while Miss, your good name, please?
SV Dara.
SP Dara, learned amicus curiae, and Mr.
G Tado,
G Taro, learned
additional people.
additional PP for the state respondents are present. In view of the above list after 2 weeks.
Obliged.
So my prayer is that the matter will come up on tomorrow.
Hello.
Also, may I please mention item 40 of today's list matter. This matter may be taken up after a week, my lord.
40,
40.
this is for hearing.
Yes, ma'am.
You are for the
Petition.
petitioner
Yes, ma'am.
on the submission made by the learned counsel for the petitioner. List is matter after 2 weeks.
Yes, ma'am. And may I please to mention another item 44 and 45.
Hmm.
Here, earlier I represented one of the petitioner. So I am withdrawing from the case. So I have instructed a client to engage a new counsel. But
Okay.
they couldn't do so far. So this matter may be taken up after 2 weeks, matter.
They're aware that you're withdrawing, is it?
Yes, I have informed them.
Mr. Your
D
good
Laji.
name?
D Laji.
D.
Laji. L-A-J.
Laji.
Yes, ma'am.
You're for the petitioner.
Yes, madam.
Your name is not there in the cause list.
In the 44, in the respondent side here. In the 45,
44, you're for the respondent.
yes, in the 45, I
So
was for the
45, you're for the
petitioner.
petitioner.
Yes, madam.
So you're withdrawing as a counsel for the petitioner.
In both the cases, I'm withdrawing, bro.
Okay.
My lord, in this case, in 44, I am for the petitioner. In 44,
Okay. Then, Mr.
L10.
Okay, so and so. Learned counsel for the petitioner is present, while Mr. D. Daze, is it?
Yes, madam.
D. Lazi,
Yes.
learned counsel for the respondent, submits that he will be withdrawing. Yes, Wakalatnama,
Yes, madam.
is it?
Yes, ma'am.
And will no longer represent respondent number, the respondents?
Yes, madam.
The respondents. He also submits that the respondents have been duly informed. However, in the interest of justice, notice may be issued to the respondents.
Yeah.
Okay, list after
3 weeks, ma'am.
2 weeks, just after 3 weeks.
Yes.
Now, in 45, Mr. D. Laje, learned counsel for the petitioner, submits that he will be withdrawing from representing the petitioners and has duly informed the petitioners. Anyone appearing for the respondent?
Lordship, I am for the respondent.
Okay, Miss H. Zeram, learned counsel, learned government advocate
Yes.
for the state respondents, and Mr.
In 45, my lord, I am for the petitioner here also.
You're for the, no, 45 is for the petitioner.
They have engaged the new counsel, already engaged new counsel since.
Okay, that-
Okay, while Mr.
Eltony.
So and so submits that, he will be representing the petitioners. On the submissions made by the councils for both the parties, matter is to be listed after 3 weeks, I think.
3 weeks, yes.
Most of it.
Highly obliged.
May Lordship, I beg to mention this on WPC number 122/2024. It's a service matter for
One?
listing 122 WPC
1 and 2, huh?
122 WPC number 122, not item number,
you-
unlist matter. Yeah,
Okay. huh,
mentioning for listing.
Okay, yes.
Yeah, for
What's the
29.
urgency in the matter? Why can't you do it in the usual process?
Urgency is that a senior will be coming from the Guwahati, and on 29th there is a other more case. He'll be coming and appear. And
Okay, allowed, huh? Chalo, allowed.
yes, on 29th.
May Lordship, I beg to mention item number 43. The matter may be listed after 2 weeks as the leading counsel is still out of station. Lordship.
43.
43, Lordship, for the petitioner.
Mention is made on behalf of, who's the senior counsel? Mr.
Elbam.
Elba Learned, leading counsel for the petitioner for adjournment of the matter since the leading counsel is said to be out of station. In view of the above, list after 2 weeks.
2 weeks, Lordship. Most obliged, Lordship.
May Your Lordship, I'm appearing on behalf of the standing counsel, Mr. Tabatagum. And I'd like to mention item number 27, Your Honor.
37,
27.
27.
Yes, Your Honor. We are yet to receive the Paravas reply from the department. So we are yet to receive we are yet to receive the Paravas reply from the department.
Huh.
So the matter may be listed after 4 weeks.
Yeah, for the respondent.
I'm for respondent 7 and 8.
Mention is made on behalf of Mr.
T. Tagum, standing counsel of
P.
health.
Taugun, standing counsel for respondents number
7 and 8.
7 and 8. For adjournment of the matter since they have recently received the Paravise comment. In view of the above, list after 2 weeks.
Your Honor, maybe 4 weeks, Your Honor.
But-
We are yet to receive the Paravas reply.
Okay,
So-
who submits that they have yet to receive Paravise comments and that the matter may be adjourned. In view of the above, list after 2 weeks.
Obliged.
Yeah, Lordship. Lordship, I beg to mention item number 28. On be-
28.
Yes,
Ah,
on
28.
behalf of N father. Kindly this
what?
matter may list after 1 week.
Mention is made on behalf of Mr. N. Pada for adjournment of the matter. In view of the above, list after
1 week.
1 week.
Lordship, I beg to mention item number 19 and 20.
19 and 20, huh?
In item number 19, I'm for respondent number 2.
Both the items are fixed. What happened?
Senior, the leading counsel is out of station.
You're for the
I'm
respondent,
I'm appearing on behalf of respondent number 2 for
respondent number
agriculture
2.
department. Yes. Or for standing counsel for our department. On behalf of El Parme.
Mention is made on behalf of Mr.
El Parme.
El Pare, learned counsel for respondent number 2 for adjournment of the matter since the learned counsel is said to be out of station.
Lordship, I'm for respondent number 9 and 10. We are the executing agency.
You see, when both the respondents stand on this side, I tend to get slightly confused. If you're for the respondent, stand this side, huh? Then Mr.
Nkera,
Nkera appears on behalf of respondents number
9 and 10.
9 and 10, while anyone else, okay. In view of the above submissions, list the matter after
Lordship,
weeks.
If it can come up on the 20th of May, I mean, outstation council, 6 days would suffice for us.
Okay, in view of
20th
the
of May.
above, list this matter on 20. Okay, 20 May, 2023.
The item number. In 20 also.
19 and 20, same, similar place.
For 20, I'm for respondent number.
Two, okay, was mentioned, responded number 2. Yes,
Obliged. Lordship, both would come on the 20th, certainly.
oh, both of them on the 20th.
And Lordship, item number 29, I'm
Twen-
appearing on behalf of K lawyer for the petitioner.
You are for the petitioner,
Yes,
you are appearing for Mr.
K lawyer on behalf of
K
K.
lawyer. Mention is made on behalf of Mr. K lawyer, learned counsel for the petitioner for adjournment of the matter. Why has he prayed for adjournment?
Is our leading counsel is out of station.
Since the leading counsel, Mr. K lawyer, is out of station.
Matter may be taken up after 2 weeks.
I'm for private respondent number 4.
Mr. So-and-so appears on behalf of private respondent number 4. In view of the above, list the matter after 2 weeks.
And Lordship, interim order that may be continued.
Meanwhile, the interim order passed earlier shall continue till the next day of listing. Yes,
And Lordship, item number 42.
42.
Yes,
Hmm,
I'm for the petitioner.
yes.
Matter may be taken on after on next week.
Is your name here in the cause list?
No Lordship, I'm
Okay, mention is made on behalf of Mr. L.
El Par-
Parme.
El Parme.
Yes, learned counsel for the petitioner for adjournment of the matter, since the learned counsel is said to be out of station. In view of the above, list after
Next week. Next week.
2 weeks, 2 weeks, list after 2 weeks.
May I please, your lordship, item number 21.
Hmm,
In that case, the state has to file their affidavit, so let the matter come up after 3 weeks. your lordship.
The state has to file their
Affidavit,
counter affidavit. They have
Yes.
not filed yet.
no.
Who is for the state?
I have already informed, your lordship. I have already
Okay.
informed.
Then, you are Mr.
I am accusing, your lordship.
Mr. So-and-so, learned counsel for the petitioner is present while the state respondents are yet to file their counter affidavit. In view of the above, list the matter after 2 weeks.
My lord, items 6 to 18, these are similar matters, my lord.
Yes, all similar.
Yes, my lord. Here, in some of the cases, we are yet to file our affidavit. Similar matters, we are
So
yet,
you're for the respondent,
Yes,
isn't
ma'am.
it?
yes, ma'am. So can this, there are other matters also which has not been listed today. So can these matters be listed after 3 weeks, ma'am?
Okay, you are Mr.
N. Ratan,
N. Ratan, learned
additional AG.
Edition AG submits, prays that this matter may be listed after 3 weeks, since they have yet to file their counter affidavit in some of the writ petitions. Okay.
Please, Lordship, I'm representing in item number 13, and there is an interim order, so interim may be continued.
Okay. Miss
El Lombe,
N. Lombi, learned counsel for the petitioner, is present and as prayed for, interim order passed earlier in WPC 139/2023 is to continue till the next returnable date.
much obliged, Lordship.
May I, your lordship? Your lordship, I beg to mention item numbers 33 to 38 on behalf of Mr. P.K. Tiwari for NHPC. Your lordship,
Also a whole bunch of cases, isn't it?
yes, your lordship.
Mhm.
These matters are currently pending adjudication before the Honorable Supreme Court, your lordship.
33 to
38.
37, no, 38.
38, yes, your
Hmm.
lordship.
My lord, here I am appearing for the, some of the cases for maximum constitutional matter. The case pending before a Supreme Court.
What is pending? The IA?
No, my lord.
There's an IA here. What is the IA about? 33, item number 3, there's an IA.
Yes, my lord.
What is the IA about?
IA is one, my lord, bringing some materials before this honorable court, my lord, in the main writ petition, my lord. My lord, may I pray that let the matter may be, my lord, posted after, my lord, 3 weeks, my lord.
So we will pass the order in the IA or in the WPC?
In all the connected matters, my lord.
So you see the last order, whether it's passed in the IA or in the WPC. Okay. Mention is made by the learned counsels for both the parties that the matter,
No, my lord, it's a altogether different matter, my lord, which is pending before the Supreme Court, my lord.
okay, learned counsels for adjournment of the matter. Okay, in view of the above, list after 3 weeks.
My lord.
Yes.
6 weeks, your lordship.
Why 6?
I was instructed to pray for 6 weeks.
Who is for the petitioner? Who is appearing for the petitioner? Both of you.
In some of the items, we are the petitioner, and in some, we are the respondent.
Is there any urgency in the matter? They have prayed for 6 weeks. Any urgency in the matter? The petitioners should be pressing the matter actually. But we don't know who is the appearing for the petitioner.
My lord, I am for the petitioner, my lord,
Yeah.
in maximum.
So is there any urgency?
Yes,
The matter
there-
he has prayed for 6 weeks.
My lord, let it be after 3 weeks, my lord.
3 weeks, see what is the position.
Yes, my lord.
Okay, and then we'll see whether further adjournment is required or not. Because you're saying the matter is pending with in the apex court, but he's saying it is not. Okay, but I'm not very inclined to look now what is going on. So after 3 weeks, let's see what
Fine.
happens. Okay, after 3 weeks.
Much obliged.
May it please your lordship. Beg to mention item number 25. Kindly it can be taken after 2 weeks.
Okay, Mr. D. Pangye,
Right.
learned counsel for the petition, has prayed for adjournment of the matter. Accordingly, list after 2 weeks.
Obliged.
Please, your lordship, I beg to mention item 4.
4.
Yes. My lord, kindly can this matter be taken up after 4 weeks, lordship?
Okay, for the petitioner, isn't it?
I'm for the
Miss-
petitioner.
Miss
And Duncan?
N. Dangan, learned counsel for the petitioner, has prayed for adjournment of the matter. In view of the above, list after
4 weeks.
4 weeks.
Obliged.
Item number 1.
May it please your lordship.
Yes.
My lord, here, learned friend was supposed to bring instructions today. Mr. Tafo. 12/3/2024 order.
Yes,
I
so,
understand the instructions are not there. He told me that the instructions has not come.
so it is the urban development
Yes,
department
yes.
who is to give.
Mr. Tafo was here.
Okay, it is not a. Mr. D. Pangin, learned counsel for the petitioner is present, while Mr. P. Tafo, learned standing counsel for urban development and housing department, is not present. It is seen that by this court's order dated 12/03/2024, Mr. P. Tafo, learned standing counsel for urban development and housing department, government of Arunachal Pradesh, is to receive instructions as to in what manner the conclusions so arrived that the rates quoted by the petitioner firm as well as the respondent number 6 firm in pursuance to the NIT dated 13/01/2024 was decided to be abnormal in nature. Okay, this second para. However, since Mr. P. Tafo is absent today, list this matter after 2 weeks.
Madam.
In the meantime, the learned standing counsel for the urban development and housing department is to inform the court of the instructions as directed by this court, write its order dated 12/03/2024.
Item number 2.
May I please, Your Lordship?
Hmm.
The petitioners, 93 numbers, Lordship. The petitioners, their lane is sought to being dispossessed by a scheme for construction of roads, Lordship.
Hmm.
Now, Lordship, this is tender notice was issued, it was cancelled. Then again it was issued, it was again cancelled. But from the online, it is visible that the tender is still active and alive. And in fact, they have on 2nd of April, they have published another corrigendum in this tender matters, saying that the last date has been, last date of submission has been postponed till 25th of this month. Now, Lordship, as per the guidelines, these roads are for construction roads or under PMGSY, Pradhan Mantri Gram Sadak Yojana. As per the guidelines, Lordship, there is no specific procedure for acquisition of land, Lordship. But they are supposed to do certain things, like they are supposed to take the consent of the villagers, and those consent may be taken in the form of affidavits and so on, Lordship. Lordship may see page 135.
135.
135.
If there are no guidelines,
Ye-
then how
yes,
do they
the-
go about?
Yes, Lordship. Lordship may see page 135, 6.12. It will be the responsibility of the state government, district panchayat, to ensure that the lands are available for taking up the proposed road works. A certificate that land is available must accompany the proposal for each work, each road work. It must be noted that PMGSY does not provide funds for land acquisition. This does not, however, mean that the acquisition cannot be done by the state government at its own cost. The state government may also lay down guidelines for various for voluntary donation, exchange, or other mechanisms to ensure availability of land. The process for making land available for the roads should subserve the common good and also should be just and equitable. The details of land made available should be reflected in the local land records to avoid dispute. Now, this is then 6.13, Lordship. It may be noted that the road works are sometimes held up because of the time of preparation of DPR, actual availability of land was not investigated, or because local panchayat was not taken into confidence about the proposed alignment, and disputes subsequently arose. As part of the PMGSY process, all states must include a simple non-formal transact work to be organized by the assistant engineer at the time of preparation of DPRs. The Panchayat Pradhan, local Patwari, and JE would participate. Forest department officials would be included where forest land is likely to be involved. So when they are trying to take the land, the transact work, as mentioned in page 137, this has to be done, Lordship. Page 137, Lordship may turn. While commencing with the preparation of the DPR, the PIU will hold a consultation with the local community through the mechanism of the Gram Panchayat in order to determine most suitable alignment, sort of issues of land availability, including forest land, moderate any advanced social, environmental impact, and elicit necessary community participation in the program. For this purpose, the PIU will organize an informal transact work as follows. Number one, the transact work shall be undertaken by the AE/JE accompanied by the Patwari and the Pradhan/Panch of the Panchayat/ward with, after adequate advance publicity, the local forest official may also be associated. During the work, issues relating to alternative alignments, land requirements for the road, and its impact on landowners will be discussed with members of the local community present. Environmental impact on vegetation, soil, and water, etc., shall be identified for resolution. During the work, due during the work, due opportunity shall be given to interested persons to put forward their point of view. At the end of the work, alignment will be finalized after recording the issues that arose during the work and the action taken, proposed proposed to resolve the issues. This shall be reduced to writing in document by the secretary of the Panchayat and countersigned by the Panch Pradhan. A copy of the document shall be attached with the finalized DPR. So when they prepare the DPR, the detailed project report, they have to take into confidence that whether
The
land is
persons
available.
concerned, huh?
Yes, conduct this transact work. So Lordship, in view of this, there was a letter issued by the secretary, that is RWD, that is respondent number 2 herein. This is page 61, Lordship.
Yes.
Page 61, the type copy is at page 63, Lordship.
61,
In the
yes.
second paragraph, Lordship, this was written to the Deputy Commissioners of Tawang, Isyang, Kra, Dadi, Kurungkume, Upper Subansari, Upper Siang, Siyomi, Lower Dibang Valley, and Anjao. Now we are concerned with Kurungkume district. Now, Lordship may see page 63, para
Which
2.
district? Kurungkume.
Kurungkume,
Okay, huh.
yes. So this was a letter with regard to the acquisition of land, which was written by the respondent number 2 to the deputy commissioners of this concerned districts, Lordship. Page 63, Lordship. Para 2, Lordship. The land being a state matter, it is the responsibility of the state government oversee that the lands are available for taking up the proposed road works. The process of main land available for the road work should be just, equitable, and serve the common good. The details of land made available should be reflected in the local land records to prevent dispute. It must be noted that the central government does not provide funds for does not provide funds, may also be unable to cover this cost. To address the issue of land signing of acquisition under PMGSY. On the other hand, due to resource constraints, the land acquisition, it has been suggested to explore mechanisms for voluntary land donation / signing of MOU. Such voluntary donations should be documented through affidavit, copy of which shall be forwarded to the local revenue official for making necessary changes in the ownership / potential record of the land. Of the voluntary donations and proper community in decision-making process, foster a sense of ownership and ensure that the road project aligns with the community's needs and priorities. It also helps in identifying the potential challenges and solutions. A specimen of such affidavit is enclosed in documenting the voluntary land donations. So, Lordship, since there is no regular process of land acquisition, the thing they have to follow is they have to explore whether the land can be donated through consent. Such consent must be through some kind of affidavit. And while taking the transact work, these things should be taken into account, Lordship. It may be noted, Lordship, that before the preparation of the DPR, the land availability certificate should be enclosed with the DPR. Now, because of this, Lordship, they had floated the standard notice. Because of this, we had met several objections verbally also. Then, since they did not listen to us, we also made several representations against this, Lordship. That is at Lordship, the representations start at Lordship. Page annexer 6 series, Lordship. Each of these petitioners have jointly and some of them singly wrote this representation, page 65 onwards, 6 series. It was not heard. Then, Lordship, I have also annexed the DPRs, Lordship. There is a last annexure, page 157 onwards.
DPRs
of these projects, yes.
Without the consent.
Yes,
without
there is.
consulting the
Yes, yes.
petitioners. Okay.
So, Lordship, we are not against any project. Of course, it is to our benefit. But at least since, in fact, when land is taken, I'm not even sure whether this PMGSY guidelines is legal or not, because the law says that if you have to take the land, it has to be through a proper process, Lordship. Here, Lordship, they want us to donate the land involuntarily. Only then things will be done. That is what they are saying, Lordship. Now, even that has not been done. Even the minimum requirement, leave alone the land acquisition process and all that, I'm not even saying. Even the minimum thing has not been done, Lordship. Now, in a similar case, Lordship may see page 139. In exactly similar circumstances, this Honorable High Court has passed this order staying the tender process, Lordship. Page 169, Lordship.
One 69.
Oh, 139, sorry.
Oh,
139.
so the effective order will be where?
139.
153, I think.
No, Lordship, 139.
139.
Yes.
Just the parties' names, but the.
Page.
Yes, page 139.
Yes, this
WPC
is the,
99.
yes, Lordship, this
So
is
the
not the
effective
operative
cost,
portion, but it starts with 139.
Yes.
151
Hmm.
is the order. Lordship may see 152,
Hmm.
third paragraph.
Hmm.
Here it is slightly different, but in my case is even better. In my case, there is no land availability certificate. The grievances raised in the present proceeding by the petitioners is that the respondent authorities have issued land availability certificate for construction of road in question, which includes areas covering the lands of the petitioners, and it is contended that the said lands of the petitioner have not yet been acquired by the authorities, nor have they voluntarily donated the land for the purpose of construction of the road in question. The PMGSY scheme mandates it is the responsibility of the state government or district panchayats to ensure that the lands are available for taking up the proposed road works under the scheme and certificate, and that land is so available must accompany the proposal for each work. The said scheme also stipulates that under the scheme, no fund is provided for land acquisition, and such acquisition shall have to be made either by way of acquisition by the state government concerned or on its own cost, or procured from the land owners by way of voluntary donations. The petitioners have also relied on the communication from the Additional Deputy Commissioner Chayang Tajo, East Kameng District, wherein it has been stipulated that land availability certificate were issued in anticipation of agreement for donation of land by the villagers. In view of the state position and clear stipulation as concerned in the PMGSY guideline scheme, it is provided that a respondent shall, before issuing the NIT for construction of the road in question, shall ensure that the lands requisite for the purpose is either acquired by the state government or procured from the landowners so affected by way of donation.
Hmm.
It is clarified that the court has not restrained us from proceeding to construct the, but only required that authorities shall undertake the construction strictly in accordance with the provisions of the PMGSY scheme. Now, Lordship.
This is an order
Yes,
issuing notice, isn't it?
yes,
So similar case is also pending. But
yes.
it's slightly different. So,
Yeah, different district, of course. But here also, here in this case, what happened is they have issued the land availability certificate in anticipation of an agreement. In anticipation of the agreement with the villagers. Actually, there has to be an agreement before issuing the land availability certificate. In this particular case, Lordship. In my case, Lordship, even the land availability certificate has not been enclosed. My case is even better, Lordship.
Your case is different from the instant case you have read. So you want notice to be issued, isn't
Yes,
it?
Lordship. And also, Lordship,
Oh.
stay the process of the NIT, Lordship.
Now, here in your synopsis,
Yes.
you have mentioned that the NIT is cancelled.
It on paper, it is cancelled, Lordship, but it has not been actually cancelled. I will show, Lordship. Lordship may first turn to page
When there's
Page 49,
when
Lordship.
there's this thing,
Yes.
when you yourself has mentioned that it is cancelled, then how can we stay something which is already?
No,
cancelled?
Lordship. Lordship will see, Lordship. Page
Yes.
49. It was cancelled twice, Lordship.
Okay, page.
49. This is the e-tender notice,
Hmm.
5th February 2024. Page 49.
Yes,
This
yes.
is the first NIT.
Mm.
Then Lordship, page 50. This is the cancellation of that NIT, Lordship. 7 February. Just in the bottom, Lordship, small one,
Okay.
page 50.
Mm.
Thereafter,
Cancellation.
I have made a type copy, Lordship,
Oh,
because
yes,
it's so
yes.
small. The cancellation of that advertisement,
Mm,
Lordship.
mm,
Then page 51, Lordship.
mm.
51, here, Lordship, in the bottom part is the second NIT
Mm,
after the cancellation, 13/3,
mm,
24. Then the top one, it is again the cancellation notice.
mm.
This is 15 March, Lordship. Thereafter, Lordship, in the PMJSY tenders, they have this website where they show the active tenders, Lordship. In the PMJSY website tenders, page 54, Lordship. In page 50, starting with page 54 is, of course, regarding other tenders, but mine starts from page 55, serial number 486. 486 onwards, Lordship. All these, Lordship, these are still active, Lordship. And thereafter, what they have done, Lordship may see page 59. Page 59, this is 2nd April, Lordship.
Mm.
In that same NIT, they have issued a corrigendum. May I read, Lordship?
Mm.
This is information to all bidders that because of assembly come parliamentary election, all staffs engaged in election duty, as well as some technical issues at BOQs, the tender scheduled to be open on 3rd April is hereby postponed. It will be open on 25th April. Tender submission will be extended for this. The following packages or this for necessary action, please. Now, these tenders mentioned, Lordship, these are part of that NIT, Lordship. All these, Lordship. Then, Lordship, the next page also. Here also some of the tenders, they're in 26 packages, Lordship, but we are concerned with only 12, Lordship. Here again, it is mentioned, Lordship. There has been postponed, Lordship. So the tender is still active, Lordship.
See,
It is only on,
your apprehension
Yes.
is that the tender is still active.
it's not
But-
an apprehension,
but-
Lordship. It is the truth,
Okay,
Lordship.
no, but,
Yes.
but when there is a notification saying it is cancelled,
Yes,
if it is the NIT is acted upon,
yes.
you can always challenge.
No,
Because
Lordship,
here it
they have,
says that it is
they,
cancelled.
they have apparently not cancelled because otherwise why would they issue this notice, Lordship,
But
corrigendum?
when there's a notification in the newspapers, saying
Yes.
it is cancelled,
Yes.
then you can presume that it is cancelled.
No, I cannot presume in view of the corrigendum and also in view of what is given in the active tender websites, Lordship. PMJSY tenders, Lordship. It's 54, Lordship.
But there's a clear notification in the newspaper
Yes,
saying it is cancelled.
yes.
If it is cancelled,
I am saying that the cancellation which they are showing in the
Uh.
paper, it is just an eyewash because PMJSY, in case of tenders, Lordship,
who issued the cancellation, let's see.
executive engineer. And the person who has made this corrigendum is also the executive engineer. So Lordship, when in PM,
Okay, what does the corrigendum say? The cancellation is there. After the cancellation, a corrigendum has been made, is it?
yes. Saying that the date for submission has been extended in respect of this works. Now, this works includes that NIT, Lordship.
But I think you will have a good case.
Yes,
if they
Lordship.
Act upon the.
No, they're obviously acting
NIT.
upon it, Lordship. They're obviously acting upon
So
it.
what's going on right now? Nothing is going on.
No,
Because-
now,
because
Lordship,
You can always submit that
Yes.
there's a notification, cancellation notification.
yes, Lordship. But
There's
Lordship,
already a
but Lordship,
cancellation notification.
the things that are published in the newspaper, those are for information only, Lordship. Those things which are published in the office, Lordship, which may or may not require publicity, Lordship. We have to take this as the truth, Lordship, because they have issued this corrigendum saying that the opening of the tenders has been postponed till 25th. And also, most importantly, Lordship, in the PMGSY website, Lordship, they have shown this to be active tenders, Lordship. In PMGSY tenders, in the website, they publish what are the tenders that are active, what is the process of those tenders, All these things are given, Lordship. Now, these are included in the PMJSY
Okay,
website,
we
Lordship.
issue notice, we'll ask the respondents to explain, isn't it?
Lordship,
What
till
is-
then, Lordship. Otherwise, if they go ahead with this, I will have no case, Lordship. If they take away my land,
Okay, who's representing the respondents?
My lord, prayer of the petitioner is also not clear. Whether they want to participate in the tender process,
no, we are not
Why-
concerned with the tender
whether
process.
they want land compensation, it is not specific.
What is your prayer? Let's see.
Why would I ask to participate, Lordship? That is not my concern.
What is your prayer?
My prayer is to set aside that tender notice because before they are supposed to give the land availability certificate with the DPS, that has been done. So it is not a valid tender, Lordship.
So you don't want your land to be acquired?
Yes,
I think
Lordship.
that's the main thing,
Yes, and
isn't
also
it?
to abstain them from illegal occupation, Lordship. So in view of, I'm really not,
Let's see your prayer portion.
Yes, Lordship.
Since you
prayer one is,
accept
yes,
objection.
page 38, Lordship.
Hmm.
Prayer one is the suite of certiorari for quashing and setting aside of the impugned NIT in respect of seal numbers 40, 51, 53, 54, 55, 59, 58, 60, 61, 62, and 63. Then also the same writ of mandamus to abstain them from illegal occupation, which are going to be affected by this NIT. Then, Lordship, the interim prayer is, of course, for suspending any further process in NIT.
And we will issue notice first.
Lordship, this tender process may be stayed, Lordship.
Yes, we'll say that not to finalize.
Lordship,
anything,
yes, not to finalize.
finalize. Mm. Heard Ms. L. Dange, Learned Counsel for the petitioner. The instant writ petition has been filed challenging the legality and the validity of the NIT number EE/RWD/LY/tender-VVP/2023-24 dated 13/03/2024, which was issued for 26 numbers of package, full stop. The projects are for construction of roads, issued and sanctioned under Vibrant Villages Program, within brackets, VVP, close bracket, for 2023 to 2024 for the states of Arunachal Pradesh. Initially, NIT number EE/RWD/LY/NIT/VVP/2023 dated 05/02/2024 was issued but was cancelled on 07/02/2024. Thereafter, the second NIT number
It's same, except
Same,
the date.
okay, yes.
Date is different, 13/3.
was issued on 13/03/2024. Comma. However, a corrigendum for the impugned NIT was issued on 15/03/2024, wherein the NIT has been cancelled. Full stop. In spite of the cancellation of the said NIT dated 13/03/2024. It is submitted that this was no, it is the case of the petitioner that this is an eye wash since the submission of bids through e-procedure 03/04/2024 up to 1,000 hours within brackets time is still showing valid on online. Full stop. Thereafter, the chief engineer within brackets PMGSY close bracket had issued a letter dated 28/03/2024 to the superintending engineer Rural Works Circle, Pasigat /Itanagar/0/Pura/Neo and Balm. I will give my dictation later. You will issue notice,
Lordship, the further process may be stayed.
because if I talk too much,
Lordship.
my cough starts troubling me. Okay.
Lordship, before this is over, Lordship, it may be noted that I am not concerned with the 26 packages. I'm concerned with only 12 packages, which
Okay.
is mentioned in the prayer,
But
in
a
serial wise.
synopsis.
Serial wise. In the synopsis also it's mentioned, but in the prayer it's specifically mentioned. So if sorry,
Yes.
so if NIT process is to be stayed, it is in respect of only these 12 packages, Lordship.
Let's see, preposition.
Yes, page 28. Sorry, 38. Others will be affected otherwise if this is not taken care, Lordship. That is why. The serial numbers in the NIT.
Page 38.
Page 38, the last three lines. Serial numbers 49, 53, 51, 52, all these numbers, Lordship.
Okay, you leave some space, okay? Then the learned counsel for the petitioner submits that the rights of the petitioners have been adversely affected, would be adversely affected if their lands were acquired without following the stipulation in the PMGSY scheme. Since none of the petitioners have volunteered to donate their land. Okay, I think that's.
Yes. Kindly, the further process may be stayed.
She further submits that the process for furtherance of the NIT number, this is 13/03/2024.
In respect of those.
Okay, in respect of serials number, that is 49, 51, 53, 54, 55, 57, 58, 59, 60, 61, 62, and 63 may be stayed till the disposal of the instant WPC writ petition.
Maybe till returnable.
She just prayed for that,
Oh.
isn't it? Having heard the submissions made by the learned counsel for the petitioner, this court find it appropriate to issue to issue notice to the respondents through registered post with AD returnable within AD within 1 week, returnable by 3 weeks. Mr.
Lordship, steps would not be required because these are all
Yes.
government respondents, state respondents.
Okay.
There is no
Mr.
private
Yes,
respondent.
yes.
And for 2 and 4.
I'll only give extra copies, Lordship.
Okay, Mr. So and so, learned counsel for respondents number
2 and 4.
2 and 4. And Miss
P. Pang for
P.
respondent number
Pankaj
1.
for the state respondents number
1, Your Lordship.
1 are present and accepts notice on behalf of the state. No need to issue
2,
formal
3 and 4.
notice. 2, 3 and 4.
Current to rural part.
You're the standing counsel.
Yes.
Okay, standing counsel. No need to issue formal notice. Requisite copies of the petition are to be duly furnished to the learned counsels for the respondents. In the meantime, as prayed for, the operation of NIT so and so, okay,
Yes,
is to be stayed till the next.
in respect
date.
of those serial numbers.
So and so is to be stayed till the next returnable date. List after 3 weeks.
Almost.
We will complete the others later.
Item number 3.
I don't want you all to suffer because of my cough. I have some allergy, I think. Yes. Yes,
I
3.
think minor the petitioners. There,
None appeared for the petitioner on call.
minor one thing that one kindly,
The stage.
on the last order, that is 9/11/2023. That may be kindly perused, madam.
What's the last order dated?
9/11/2023.
A new council is to be engaged, isn't it? Now, whether notice has been issued to the petitioner. Now, in the last date, Mr. A. Saring had represented the petitioner. Though he had submitted that he will no longer be representing.
He is absent.
However, Mr. A. Saring has not appeared today. Okay, none appeared for the petitioner on call. Now, notice was issued to the petitioner. What does the office note say?
Oh, other Remy.
Now, on 5th to 2023-24, registry has issued notice. However, it is not known whether notice was received or not. AD card. So we'll wait for some time.
Minor, these have to be dismissed because same subject matter has been repeatedly agitating. Minor, kindly peruse this one. Actually, and this one also. Since 2017, they are dragging the respondent.
What? This is Amit Saring. What? Why are you showing me this? This is 644, 2017.
I want to show you that it is the same subject matter.
So what about this case? Has it been disposed? No.
That was already disposed of.
How was it disposed? This one, 644. Now is it the subject matter? What is the subject matter in this case?
Land,
To
land.
see. No. See, my only concern is in this case,
Yes, ma'am.
in the instant case, the court has mentioned that notice is to be issued to the petitioners. And the office note indicates that registry has issued notice, but whether the notice was received, no AD card was returned. So whether it was actually served upon or not is not known. So simply dismissing the matter without the petitioners, without the court being satisfied that the petitioner has received the notice and has not taken steps, we have to be convinced, isn't it? So none appeared for the petitioner on call, while Mr.
Ma'am, T shown, ma'am.
T. Song,
Correspondent number 567.
counsel for respondent number 567, and Ms. So-and-so, learned government advocate for the state respondents are present. On perusal of the office note dated 05/02/2024, it is seen that notice was issued to the petitioner since the learned counsel for the petitioner, the previous learned counsel for the petitioner, Mr. A. Saring, had withdrawn himself from representing the petitioners. However, it is not known whether the notice issued to the petitioner has been duly served upon, is duly served upon the petitioners. In view of the above, this court find it fit that the registry should issue fresh notice to the petitioner, wherein the petitioner be informed that when the petitioner is given the opportunity to engage a counsel to represent, so that they are represented in the instant case.
Meanwhile, my lord, mode of your service, ma'am, that may kindly be specifically mentioned, ma'am. Mode of the service, AD or with
the
registered.
AD. No, notice be served to the petitioner through registered post with AD. Okay, within 1 week. Returnable by 2 weeks. Okay, list after 2 weeks.
As a last chance.
Then
As a
let's
last
see.
chance.
Let's see what happens. Okay. See if the AD is returned or not. Simply presuming that it has been received, we cannot simply dispose of it.
If not also, my lord, they are not interested, I think. That is why. Oblige, my lord. Item number 5. Here, I think, my lord, the standing counsel of the Food Corporation of India is not present here, my lord. Well, here.
What is the stage? Here, rejoinder affidavit has to be filed by the counsel for the petitioner. Have you filed?
No.
Yeah, then, see, the last date says that you have to file your rejoinder. Are you still interested to file your rejoinder affidavit?
My lord, will file, my lord.
You'll file, okay. Mr.
RCK, my lord.
So learned counsel for the petitioner is present. and submits that he will be filing his rejoinder affidavit within 3 weeks, 3 weeks. In view of the above, list after 3 weeks.
Okay.
Item number 22.
Yeah, Your Honor.
Hmm.
Government respondent are yet to file their affidavit, Your Honor.
Hmm. Miss so-and-so, learned counsel for the petitioner is present, while none appeared for the respondents. It is seen that the respondents have yet to file their counter affidavit. In view of the above, list after 3 weeks.
Obliged, Your Lordship.
Number 23.
Yes,
My lord, I may be allowed to. I may allow 2 weeks more to file.
you're for the respondent.
I'm voted petitioner, my lord.
What do you want? Okay, affidavit in reply has not been filed. Okay. Mr. So-and-so, learned counsel for the petitioner has prayed for further time for filing of the affidavit in reply.
Yes.
In view of the above, list after 3 weeks.
Yes, Your Lord.
You want your names to be reflected?
It's okay.
The presence of Miss So-and-so, learned counsels for respondents number 1, 2, and 3, and Mr.
B type audio.
B so-and-so, learned counsel for respondents number
4, 5, and 6.
4, 5, and 6.
4, 5, and 6 is noted. Yes.
Obliged.
Item number 24.
Yes.
Your Ladyship, the respondent number 9 have to file their affidavit in opposition. Is private respondent.
So you filed your affidavits?
Yes, we have filed, RWD have already filed.
So pleadings are complete?
Yes, Your Lordship.
Okay. Miss
Sonam Thomu.
Sonam Zhu appears on behalf of the petitioner, while Mr. So-and-so appears on behalf of respondents number?
Standing counsel RWD.
Okay, Mr. So-and-so, standing counsel for
RWD.
RWD, and Miss P. Sangita, government advocate?
Yes.
Learned government advocate for the state respondents are present. It is submitted that pleadings are complete. In view of the above, matter may be listed for admission hearing after 2 weeks.
2 weeks. Obliged.
Item number 26. Yes, 26. None appeared for the petitioner, while Ms. So-and-so, learned government advocate is present. What is the state?
I'm appearing for all the respondents. Okay. 1, 2, 6.
Okay, learned advocate, learned government advocate for the state respondents is present. Okay, Ms. So-and-so. While none appeared for the petitioner. In view of the above, list after 3 weeks.
Item number 20.
Yes, none appeared for the petitioner on court. While Mr. So-and-so, learned, standing counsel, is it?
Yes, RWJ.
For, what, urban development? Is present along with Miss So-and-so, learned, government advocate for the state respondents. In the absence of the learned counsel for the petitioner, list after 4 weeks.
Problems.
31. I'm representing respondent number 11.
You are for respondent number
11.
11.
Yes.
So last time you were granted 2 weeks' time to file your affidavit. Have you filed?
I know actually here, respondent number 11, 6. In the capacity of junior engineer, I have been discharging my duty. So my affidavit will cover with respondent number 6.
Okay. Mr.
And
So-and-so, learned counsel for respondent number 11 submits that the affidavit, counter affidavit filed by respondent number 6 will be covering his matter and he will not be filing a separate counter affidavit. Yes, then anything else?
Your Lordship, I'm appearing for respondent number 1, 3, 4, 5, 6, 7, and 8.
Okay, Ms. So-and-so, learned
9,
government advocate for the state respondents is present. Anything else?
Respond, here is respondent number 12, I think, my lord. Newly implemented respondent number 12.
You are for.
I'm
newly
for a
implemented-
petitioner.
Okay, so who is respondent number 12?
12, my lord, M. Khator, my lord.
Newly impleted?
Yes, he himself implemented as a party respondent.
Where's the order?
Order, my lord,
Unless it's an application,
My lord, we filed
yes, he's
IA for implement, my lord. This land belongs to me, my lord. The petitioner.
okay. Mr. So-and-so, learned deputy, so.
No, my lord, as a private counsel.
Okay, Mr. So-and-so, learned counsel submits that prays that he will be allowed to file an IA to be included in the
No, my
instant
lord,
case.
IA has been already filed. By that IA, my lord, order of this honorable court, my lord, we have been
Where,
implemented.
where's the IA? Nothing is mentioned here. Let's see if this,
I'm sorry, sir.
let's see if the order of this in the WPC. Okay, so you have been implemented.
Yeah.
For respondent number 12
12,
submits
yes.
that you will be filing his counter affidavit, is it?
Yes.
Has paid for time. Okay, Mr. So-and-so, learned counsel for respondent number 12 has paid for time for filing of his counter affidavit. In view of the above, list after 2 weeks.
obvious.
Item number 32.
Yes,
My lord, I got the respondent 1 to 4. My lord, petitioner counsel seems to be absent.
none appeared for the petitioner. The petitioners are not appearing, it appears, counsels, in the last date also.
Last date also, my lord. 3 names are there, my lord. Idolo, B. Sharma, R. Tapu.
Okay, last date he had appeared. None appeared for the petitioner on court. Well, the state respondents are duly represented by Mr. R.H. Nabam, learned additional AG. In the absence of the counsel for the petitioner, list after 4 weeks.
4 weeks, my lord. Yes.
Item number 39.
What is the stage?
This Information Commission has to file their affidavit. One, two, my lord.
Now, affidavit concerning dusty service upon respondent number 3. Have you filed?
Yes, my lord. Already, my lord, and it has been deemed that service has been taken, my lord. By which order? I forgot, my lord. I have filed an additional affidavit, my lord, in that respect.
Where? Okay, additional affidavit has been filed.
Yes, ma'am.
And what do you mention in the additional affidavit? That notice was served to respondent number 3,
Yes, my lord.
dusty service.
Yes, my lord.
Okay. Mr. So-and-so, learned counsel for the petitioner submits that dusty service has been served upon respondent number 3 and affidavit to the effect has also been filed. In view of the above, notice is deemed to be served upon respondent number 3.
Yes.
However, none appeared for respondent number 3. Mr.
Arsakia for
Arthur
standing
K.
counsel 1 and 2, madam.
Learned standing counsel for the
Information
respond-
Commission, madam, 1 and 2.
Okay, Information Commission is present. List the matter of the 3 weeks for the respondent number 3 to be duly represented.
Problem.
Item number 46.
Forty-six, are we ready? This is supplementary hearing.
Yes.
Are we ready?
Yes, Your Lord.
Who is for the respondent? Yes.
May I, Your Lordship? Your Lordship, this is a termination matter. The petitioner was terminated in year 2014. This is fourth round of litigation.
With the petitioner, he was what, recruited as?
ITBP constable. in
Constable,
2000
okay.
Yes, 2011.
Hmm.
And during training, he got injured and he couldn't recover from there. So he was going for treatment in different places. Like first he informed to the
When did
commander.
he got injured? In which training can you mention?
Yes, Your Lordship.
When was he appointed?
In 25/10/2011.
25/10/2011, he was
Yes.
appointed as constable,
Yes.
ITBP, okay. Then he went for training.
Yes, on 25th February 2012, he got injured in this respond number 6 campus. He was in UP Bareilly. He got his hand fractured, but the respondents haven't cared about his injury. So for some time he was there, but later he didn't cure from that injury. And
do you have any documents to show that he was injured? What?
actu-
Anything to support to your claim?
There are documents, but it's of later stage. But in their affidavit, they haven't any objected for these things.
Okay.
In page number 31, there is, but it's not very clear.
31. What
Yes.
is 31?
Page number 31 of petition.
This is
not very-
dated 10/4/2013.
Yes, it's of Unit Hospital ITBP.
What does this say? This is
It's
concerning his injury, is it?
yes. It's not very clear. Actually, there are some prescriptions of his injury.
Okay, so he was injured.
Yes.
Then what happened?
And he was running for this his X-ray and all those things, and so he couldn't care. So after like on 28th February, petition was referred to Bareilly District Hospital because on
28 February.
Yes.
2012. 2012.
Yes.
It was referred to Raebareli.
Bareilly
Bareilly,
District
okay.
Hospital.
Okay, where's that?
It's in UP.
UP, it must be Raebareli. UP hospital, Raebareli they call it.
Yes.
UP.
Yes. So
Where's
The-
that letter? Letter referring him to Raebareli.
there is no letter.
Then
Actually, he don't have any letter from there, but in respondents' affidavit, they haven't objected anything about these things. Whatever it happened, he have just this unit hospital one and few of their, otherwise he don't have much
Any
of.
letter? Okay, this is the letter from Bareilly. Page 31, is it?
It's 31 is the prescription report from the
so-
ITBP hospital. It's of later stage. In between, there are many things happen, and later he went to this ITBP hospital. At least it's been 1 year that he was running here and there for his treatment.
Okay, so there's no document showing that he was. So where's the letter showing his treatment in Bareilly or Raebareli? We usually call it Raebareli.
it- No, they haven't provided the medical documents also. They have kept in the hospital, but they haven't mentioned few of the documents he have kept with himself. Otherwise, he don't have because he didn't provide it from the medical. There are in between. There are many other connecting dots, so we have to connect from that.
Okay, so what's your case? He was injured.
Yes.
So he did not go for, you see, I think here this thing is his dismissal because of what non-attending or because of his absence, isn't it?
Yes, Your Lordship.
So he was injured on 25/10/2011. After his injury,
It's
no,
on
or
2nd of February.
25/2.
Yes.
2012, he was injured.
Yes.
Okay. After that, he has not been reporting himself on
No,
duty.
it's
Is
after
it?
1 year. No, it's not.
Then
After that, on 28th of February 2012, he was referred to Bareilly District Hospital from his training center.
okay, so on 28/12/2012, is it?
28th February 2012, 28/2/2012, he was referred to Bareilly Hospital
28/2 Bareilly
for
Hospital.
X-ray.
Ah,
From 25
ah.
25/02 to 2012, he was in training center only. After 3 days, he was referred to the Bareilly Hospital because he couldn't care. And they have conducted the code of inquiry for his injury also, but they said that nothing has happened because it was just during course of training, so nobody can be held liable for his injury. And in this report, they have said that if he will face some difficulties,
Where are you
it's
reading
in
from?
para 4, page number 7.
Don't hurry, let's get the facts clear. Isn't it? It's not very clear. Page number 7, is it?
Page number 7,
Ah.
para 4, and
Ah.
annexure is in page number 40, annexure C. They have admitted that he got injured. He got injured, but they didn't hold anyone liable for that because it was during course of training. And if he will face some difficulty during his future time, then the respondents will take the responsibility that whatever will be the result, they will take the responsibility. Like,
Okay, so he was referred to Raebareli.
Yes.
On 28/2/2012.
Yes.
Then what happened?
so after that, on from 25th there is some date mistakes. It should be from 28 February 2012 to 9th April 2012. Petitioner was in ITBP Hospital, Bareilly. So it's almost more than 2 months that he was there. So it shows that his injury was like deep.
He was in the hospital
Yes.
almost 2 months.
Yes.
Okay.
But he didn't get any proper treatment because it's kind of district hospital and we know the situation of district hospitals.
No
Then,
documents to support that he's in the hospital?
I don't have any documents. They just have given the painkillers.
So for 2 months he was absent. Then
Yes.
what happened?
Yes. So for this, they haven't objected anything from respondent side that he was not there and all these things. For this, they haven't objected anything. There's no objection that he was absent.
Obviously, they
Yes,
won't
because
object
yes.
because he was absent.
No, they didn't count it as absent because they know that he was injured and they themselves have sent him for this treatment.
Okay. They what?
The respondent, they themselves have sent for the treatment.
They
in
sent
Berkeley.
him for
Yes,
treatment.
Yes, but there's no
Okay.
document for that, but they haven't objected for those things in their affidavit.
Respondents sent him for treatment.
Yes,
Is it?
but there is no documents to show, but they haven't objected in their affidavit. After that, he went back to the center. On 10th April, petitioner when he went back to the Port Battalion where he was appointed. It is in Dirang, Arunachal Pradesh. He again complained for the this.
When did he join duty? He joined on?
Yes, 10th. 10th of
what?
April 2012. He again complained for joint pain for his injury. The doctors, doctors gave painkiller there in unit hospital. It is in Dirang. So after that, from there,
Where?
It's in Para 6.
Para 6.
Yes.
Okay. Painkiller was given. Huh?
Yes. After that, so it's very small unit, so they couldn't take him properly. So they referred him to the CRPF Guwahati for ortho consultation. On 19th May 2012, they sent him to CRPF Guwahati. From there, petitioner was granted 42 days leave. So 42 days leave shows that his injury was very deep and it was not curable or treated there properly. So they have sent there for 42 days leave. For this also, they haven't objected anything in the petition. It means their affidavit for 42 days leave. He don't have any these documents, but they have granted 42 days leaves. It is from CRPF Guwahati, so it is their own hospital, CRPF. So from 5/6/2012 to 16/07/2012, he was there in leave, but his leave is already completed, so he couldn't stay. So he went back. His hand didn't cure till that also, but he went back after 42 days to his unit. 17th of July 2012, he was again. He reported back on 17 July 2012. The petitioner consulted with doctors of CRPF and was told that further operation is necessary. Later, he was consulted to CRPF.
Okay, let's see the medical leave certificate.
It's in page number 42, annexure D.
So he was given medical leave with effect from 5/6/12 to 16/7/12.
Yes.
42 days, huh? Then?
So when he completed this leave period, he went back but it was not cured because at that time he was very young and no one was there at home to care for him. And so he completed his leave period, so he went back, but it was not cured. So he again went back to this CRPF hospital for consultation of doctor to Guwahati, but doctor told him that operation is necessary for his condition. And X-ray have been done in Guwahati Medical College. Maybe the CRPF hospital doesn't have that provision, so he went to Guwahati Medical College. So X-ray have done many times before also, but here it shows same thing, that he sustained fractured. So it's now already in the month of July and he fractured in month of February. So when the injury got old, it's more worrisome for the patient. So it was difficult for care now. So again in Guwahati Medical College also he get painkiller only. Just from CRPF Guwahati they have prescribed for this operation, but when he went to Guwahati Medical College, then also he didn't got proper care, and he was alone, and he was just 19 or 20 years of age. And
Where's his birth certificate? Where's his age shown?
It should be in his appointment letter, 24. Your Lordship, it is somewhere here, but I forgot where I saw now. If I will remember later, I will.
Okay.
Yes. So at home also he his mother was also not very well, and father was also old, so no one was there to care. When he went for 42 days leave also, he didn't got proper care. And so in
para 10, on 12/9/2012, he had applied for leave.
Yes.
For how many days? The unit approved for his leave. For how many days was he given leave?
actually, during this time, he didn't mention any proper days because he didn't know how many days he were going to stay. Because
But when you apply for
yes,
leave, there could be a certain number of days, isn't
yes.
it? You can't
Actually,
just apply
he
for
missed
leave.
that application number. Actually, in this application, they have granted the leave. They have
For
granted.
how many days?
I didn't got that
So
application.
find out, isn't it? Because when you grant leave, the number of days have to be mentioned.
Yes, Your Lord.
Because I think your case is being not on duty for quite a number of days.
Yes.
And therefore he has been dismissed
For
from service.
this
So you have to see whether the dismissal order is reasonable or not. Then
Yes.
you have to give your grounds,
Yes.
isn't it? So many days leave. He
Yes.
wasn't actually a deserter. You have to show that in the
Yes.
court, isn't it? So I'm trying to find out.
Your Lordship, for this para 10,
Hmm.
he stayed for 46 days extra. For this, he already got the punishment. This
Where?
for
So on para 10, when his mother died.
yes. So he stayed for 40.
Okay, 46 days
Yes,
beyond
yes.
the leave granted to
Yes,
him. How
yes.
many days was granted to him?
Actually,
You
there
don't
should
know,
be the
but 46 days extra, okay.
yes.
Let's
for
see.
this.
So for that, what was the punishment given to him?
46 days was regularized as extraordinary leave. So it was already completed there itself.
Okay.
So on para number 11, on 20th of December 2012, petitioner was referred by medical officer BN Birang to Composite Hospital, CRPF, Guwahati. His hand was not very pure, and he was young, so he was also a little bit careless, I guess. So he was doing his work because he can't leave his job, so he was coming forth and back. So after coming from there on 20 December 2012, petitioner was referred by medical officer. They have granted themselves, but I didn't get any documents, but he have written application during that time. It's in Annexure G, page 45.
Okay, let's see. Page?
Page 45. Type copies in page 45A. It's it's in 44A type copy.
Okay, 45A.
Yes, Your Honor.
Here he informs them that he is undergoing treatment.
Yes. Since he was alone there, so he wants someone to accompany him there in the hospital.
Okay.
So they haven't granted anyone to accompany him there. So he was alone and he was doing all things. Because in his home also, no one was there to accompany him because mother is already died and father was old. And one brother is there who was working somewhere else and he have to do his own chores. So it's not capable. In para 12, the petitioner have mentioned that he was in Composite Hospital, Guwahati, that he didn't receive the payment during the time he stayed in Composite Hospital. This is also like, yes, in month of January 2013, February 2013, he didn't receive, till date he didn't receive that. So after that, on para 13, Your Ladyship, he on 10th June 2013 and 12th June 2013, he wrote leave application, but the authorities or respondents haven't granted him the leave. His hand was deteriorating because it's been almost a year that he was like not treated well. So his hand was deteriorating, and he applied for unpaid leave. Then also they haven't granted him. So on 15th June 2013, he left the unit without it. I don't know whether it should say uninformed or he couldn't bear the pain, so he left. Because on 10th and 12th he wrote for leave, but they haven't granted. So on 15th June 2013, he left the unit.
So he left because leave was not granted.
Yes, he even applied for unpaid leave for 60 days, but also they haven't granted it. So on 20 June 2013, they have registered FIR in Dirang police station. On 15th July, two West Bengal police came to him in West Bengal. Since FIR was registered in Dirang, but they have also informed to West Bengal police station since he is from West Bengal. So two West Bengal police came to his residence and they show the FIR copy to him. So he have given some documents, medical documents, which he had. And he was in bed, so police didn't arrested him, and they just left with his signature on one blank paper and few of his medical documents from him. So he was in a comprehension that maybe they have already provided those documents to the his like commanding officer or to his unit. They have already provided, because after that, no one came to his home. So he was in comprehension that they already got the information that he is not well and he is not able to like even stand. He was in bed at the time. So in para 12, it's in page number 12, last paras of page number para 13, that they have informed, they have issued some apprehension letter to Superintendent of Police this Coach Bihar West Bengal district, but this document he never received. He just got to know after his termination. He got to know after his dismissal. He just got to know about the FIR since the police came to his residence and they have told. So this is not, it was not in his any knowledge that they have issued any apprehension letter to Superintendent of Police West Bengal. So on 26 February 2013 and 16 November 2013, the petitioner have wrote some leave application to the commanding officer of ITBP. It's in page number 51 to 55.
Let's see.
Annexure J.
Fifty-one and?
51 to 55. Its transcript is in 52. Uh, 54 one he sent through fax.
Okay. Then?
So for this also, they haven't responded anything. So on 1st of November 2013, without any prior notification or any kind of show cause notice, petitioner, this is the deserter date, but this deserter letter he received after termination. This is also one concerning thing, because the termination was happened in 15th April 2014.
Where's the termination letter?
Termination letter is in page number 65 and deserter order is in 56.
Page 65 is the termination.
Yes.
And deserter letter is in page?
Page number 56. And for
Wait, what was the date? 56?
Sorry, Your Lordship.
The letter, deserter letter is dated 1/11/2023.
Yes, Your Lordship. Before that, he didn't receive any show cause notice.
2013, okay, and the termination letter is 15/4/2014.
Yes.
Hmm.
Before
Okay.
desertion, he didn't receive any show cause
You're
notice.
saying that you did not receive this letter, 0.
Yes.
1
Deserter order and
11.
show cause notice, both I didn't receive. Before termination, they have issued show cause notice, but I received that show cause notice after termination.
Where's the show cause notice?
It is in page number 60. If your lordship may come to page number 61, I may
Hmm.
like to,
Hmm.
it's in second line.
Hmm.
May I read?
Yes.
Show cause for alleged misconduct on your part within 30 days of receipt of the notice, failing which ex parte decision will be taken and your service shall be terminated. So since the petitioner didn't receive this show cause notice, so I guess it is wrong to say that he received any show cause notice because he received this show cause notice after termination. And termination letter also he received after 99 days of termination. Date.
How can you say that? Do you have anything? Or that is just a statement?
That is just a statement because I don't have any documents because I didn't get that document, but I received after 99 days of this termination date.
Hmm. So you were terminated on 15/01/2014.
Yes, Your Lordship.
And you received this after 90 days.
99 days.
99 days.
99 days.
So between that, you were not going anything. Where were you between those nine before you received the termination letter?
Your Lordship.
You were in the
pardon.
hospital or what?
You
didn't take the trouble
no,
to go-
after termination, I directly went to the unit, unit. And I have went there and I have verbally requested them, but they haven't granted me any relief. So
See, you received the termination letter quite late. Okay, after 99 days.
yes, on 21st June 2014, I received it.
So between 15/04 and the 21st June, where were you?
I was in home only, my residence.
Why did you join duty then?
Your Lordship, I received these all things. The deserter letter I received later. When I got to know about the termination, then I went there and I got to know that they have issued deserter letter also and the
But all this time, 99 days, 3 months, your leave is already over. You didn't take the trouble to join or what?
No, Your
You saying
Lordship.
that I'm not well, you are not well, that was shown before only.
No, Your Ladyship, 21st June 2014, I got to know about all the things that happened, like deserter order, show cause notice, all things I got to know about. Before that, I was not aware of anything, like I was deserted and they have given any
What
show.
were you doing all that time?
I was in
The hospital?
hospital only.
So do you have
because
any letter showing that you went to hospital all this time for what?
Yes,
99 days or something you were in
Yes,
the
yes,
hospital?
because of the hand injury,
When
I
you
had
prayed
other-
for 6 months, wait, when you had prayed for 6 months leave, that is
yes,
dated
yes, Your Lordship.
26/02/2013. If you had prayed for 6 months leave,
Your
then it
Ladyship-
will be over, 6 months will be over on 26. I'm looking at page 52. You had paid for 6 months leave, isn't it?
Yes, Your Lordship.
This is dated 26/02/2013. Presuming that you were granted 6 months leave, the 6 months would be over on 26/08/2013. So after your leave was over,
Actually, Your Ladyship, they haven't granted me the leave, so I was not well. I just asked for leave, so they grant, but they haven't granted, and I was also sick. If Your Ladyship may come
so
to
for 6 months you were sick.
yes.
So up to 26/08/2013, 6 months you were not granted, but you were sick. Okay, then where are your letters showing that you were sick in the hospital?
It's from page number 26 to
Okay, let's see.
page number 26 to 39.
See, we're just seeing whether you have a genuine case or not, isn't it?
Yes, Your Lordship.
Page 26. Okay. Now these are your medical letters. Let's look at your medical letters. After you applied for leave.
Yes.
Now, this letter, your first medical letter, painkiller was given to you on, issued on 11/07/2015 after your termination letter. So leave this aside.
Yes.
Okay, this is not required. Now, the next one, page 27. This
It's of-
was issued on
29/12/2014.
29/12/2014. So this is also not relevant. So we are trying to find out after your 6 months leave, you should have joined, whether it was allowed or not. You
Yes.
should have joined. After 26/08/2013. I'm just seeing why not. So now you have another letter, which is page 28, Ayurvedic treatment. So if it's Ayurvedic treatment 28, that means you were not in the hospital or what? Ayurvedic, I don't think he will send you to the
Actually, your
hospital.
ladyship, because he was injured for a long time, so he was suffering from other diseases now. So it
Like
was
what?
difficult for him to care.
What disease?
He got jaundice and other liver issues, all those things.
So where are those letters? You should support with something, isn't it? Simply saying it is not, but you have, if they don't deny it also, the respondents,
yes,
they have to categorically accept that this is true. If
Yes.
not, you have to convince the court.
Yes. Since he didn't have
Page
that
29
Yes.
is dated 20/06.
2013.
2013. Because if you have a genuine case and you were sick, we have to be considered.
Yes.
But if not, so you have to convince this court, okay, this is medicine. What is 30? 30 is very vague. It's dated what?
30 is of ITBP. It's of 2011 only. It's of a unit hospital.
This
It-
is
during-
dated 10/6/2013.
Yes. This of initial period. 31 is also same.
Oh, anyways, so you're saying that we'll have to look at your documents and see whether, but if we look at it now, we have a chance to explain, isn't it?
Yes.
So 32 is, page 32 is what? It is just a test.
Yes.
Is this a government hospital? Yes, is it or no?
It's
This
not
is where?
government. It's private.
Private. This is just urine blood sugar. Nothing important here. Doesn't show you're sick. Anyone can have this test. Routine test, isn't it?
Yes, since his home was from far away from the place, so he have to go to private hospitals and the local all the things because he didn't have much money even because he didn't receive any.
Okay, but this is routine, isn't it? Serum, William. This has nothing to do with his hand. This is blood group.
Yes, since he was
33.
he didn't treat it well for a long time, so he's like he was getting weak and he was suffering from other diseases also. It's more than a year that.
Where? Anyway, fever, jaundice, weakness, medicals. This is 05. Yeah, 0502. Anyway, so after he received his termination letter, what happened?
He went to unit in Dirang. He tried to convince the officers there in Dirang orally, means verbally, but they didn't allow him there.
So did he make any written submission?
Written submission for. It's in page number 54, that first written submission he made.
This is dated
16/11/2013. That is after the deserter order, but he didn't. Yeah, it's in 16/11/2013.
This is a leave application, isn't it? Huh? Okay, this is the leave application submitted by him. Then, yes,
After that, there is in page number 69, after termination. Before this,
what is, this is
annexure.
after the termination.
Yes, before that, he went to this commandant and verbally he have submitted his.
Leave about verbal.
Yes.
We want documents.
Yes.
So page 69, what does it say?
Request to take back because at the time he already aware of the termination, so he have wrote this application to reconsider his issue, but they haven't reinstated him. Again, it's in page number 72 and
And
70.
it says receive show cause notice on 03/01/2014. Received, okay. This is dated 17/12/2014. Receives show cause notice. Who has written this? Handwriting. Receives show cause notice. Page 70.
It might be wrote by petitioner.
Okay. Petitioner wrote this, huh? Receive
Yes.
show cause notice.
Yes.
Okay, then.
Again, it's in page number 72 to 74.
What is this, page 72?
72 is application since he didn't receive this to reinstate the petitioner for job because he was terminated. So he wrote this again on.
So he's taking steps after he is terminated.
Yes.
Okay, then he took various steps. We'll leave it at that, isn't it? Anything else?
Your Lordship, I may like to place some judgments. One I already placed to your ladyship. It's 2012 SCC 178.
Yes, 3 SCC.
Yes.
Yes.
If your ladyship may come to page number 16, para 16.
Para 60.
Yes.
Para 16.
Yes.
Yes. 16. Yes. What does it say?
Since the petitioner in the present case have been terminated because of unauthorized leave and misconduct, since deserter is about the misconduct. So in this case also it's like person was absent for a long time. So this is of Supreme Court judgment. In the case of appellant referring to unauthorized absence, the disciplinary authority alleged that he failed to maintain devotion to duty. So in desertion also it says that due to lack of devotion, so he should be deserted. So devotion to duty and his behavior was unbecoming of government servant. The question whether unauthorized absence from duty amounts to failure of devotion to duty or behavior unbecoming of a government servant cannot be decided without deciding the question whether absence is willful or because of compelling circumstances. So compelling circumstances, medical condition is, I guess it's a compelling circumstances, it won't come under the willful decision of the person.
So 17? Please, para
if the absence is a result of compelling circumstances under which it was not possible to report or perform duty, such absence cannot be held to be willful. Absence from duty without any application or prior permission may amount to unauthorized absence, but it doesn't always mean willful. There may be a different eventualities due to which an employee may abstain from duty, including compelling circumstances beyond his control, like illness, accident, hospitalization, etc. But in such case, the employee cannot be held guilty of failure of devotion to duty or behavior unbecoming of a government servant. So
so read 18. It is also in your favor.
In a departmental proceeding, if allegation of unauthorized absence from duty is made, the disciplinary authority is required to prove that the absence is willful. In the absence of such finding, the absence will not amount to misconduct. So in the present case, the inquiry officer on appreciation of evidence, though held that the appellant was unauthorizedly absent from duty, but failed to hold that the absence was willful, the disciplinary authority, as also the appellant authority, failed to appreciate the same and wrongly held the appellant guilty.
So then the respondents in their termination letter, they fail to prove, is it?
Yes, Your Lordship. Your Lordship, I may like to place one more judgment.
Okay.
It's WPC 3167. I guess I already placed in English. Para 11.
Okay, this is by a coordinate bench of this court.
Yes, Your Lordship. It's yes, it's of SSB.
Para 11.
Yes, Your Lordship. May I?
Yes, go ahead.
It may be noted that Court of Inquiry is comparable to departmental proceeding in which the disciplinary authority examines a number of witnesses and also the documents relied on by the authorities to prove the charges against the petitioner. Therefore, it is incumbent upon the disciplinary authority to inform the charge officer of the convening of departmental inquiry by informing the charge officer of the date and time. This information or notice about the holding of departmental inquiry is distinguishable from the show cause notice as to why a disciplinary action will not be taken. In present case also, they have issued show cause notice, or the petitioner haven't received. And here it's talking about the date and time of holding of the Court of Inquiry, but they haven't mentioned any particular date or time for the Court of Inquiry. Even they didn't send any letter for Court of Inquiry. They just sent show cause notice, which also he received after the termination. So it is also one point that.
This is para 4. Para 4 subclause, maybe subpara 11, isn't it?
Yes, Your Lordship. Your Lordship, I may like to place one more judgment. It's of Guwahati High Court. Since the petitioner was terminated under Rule 20 of ITBP, so it's same. Its fact is almost same. It's of 2019.
Okay.
May I? Para
Yes.
9.
9.
Yes, Your Lordship. Section 51 of 1992 rules provide that punishment may be inflicted in respect of offenses committed by persons subject to 1992 Act and convicted by force courts, which includes removal from service as provided in Section 51, Clause D of 1992 Act. However, Rule 20, Clause 2 of 1994 rules provide that if under Rule 20, Clause 2 of 1994, the petitioner was also terminated. Rule 17 is satisfied that trial of delinquent personnel by force court is inexpedient or impracticable and is of opinion that his further retention in service is undesirable. He may dismiss or remove the delinquent personnel from service after complying with the requirements laid down in Rule 20, Clause 2 of 1994 rules. para 10 is about the rule 20 of 1994. Rule 20, termination of service of persons other than officers or account of misconduct. When it is proposed to terminate the service of a person subject to the act other than officers, he shall be given an opportunity by authority competent to dismiss or remove him to show cause in a manner specified in sub-rule 2 against such action, provided that this sub-rule shall not apply where the service is terminated on ground of conduct which has laid down to his conviction by a criminal court of force court, or where the authority as specified in Rule 17 is satisfied that for reasons to be recorded in writing, it is not expedient or reasonably practicable to give the person concerned an opportunity of showing cause. When, after considering the reports on the misconduct of the person concerned, the authority as specified in Rule 17 is satisfied that the trial of such a person by the force court is inexpedient or impracticable, but is of the opinion that his further retention in service is undesirable, it shall so inform him together with all reports adverse to him, and he shall be called upon to submit in writing his explanation and defense, provided that the authority is specified in Rule 17 may withhold from disclosure any such report or portion thereof if it is his opinion its disclosure is not in interest of security of the state. So, as per the rule, he should have given the reports of all the inquiry against which he got the punishment or termination, but he didn't receive any report of the court of inquiry. Even till date, he didn't receive. And even in affidavit also, they haven't provided. And I don't think there is any security difficulty to provide this for termination issues. Thank you, Your Lordship.
Yes, read this thing, para 11, continue with the reasoning made by the court.
Your Lordship.
Read para 11, the reasoning made by the.
Yes,
court.
may I read?
Read, go on.
Mr.
You don't have
RK.
to read the names, next.
Sorry.
Has brought the official records,
As the official records and on perusal of the same, this court finds that through the competent authority has discussed the unauthorized absence of the petitioner, the competent authority under Rule 17 of the 1994 rules, that is the commandant has not recorded his satisfaction to effect that the trial of the petitioner is inexpedient or impracticable as required under Section 20. Clause 2 of the 1994 rules. As the provision of Section 20, Clause 2 of the 1994 rules has not been followed by the authority, the commandant could not have removed the petitioner from the service under Rule 20, Clause 2 of the 1994 rules. Further, the petitioner has not been removed from service in terms of Section 51 of 1992 rules. Consequently, the order dated 1st July 2016 issued by the commandant of 20th Battalion ITBP force removing the petitioner from service is hereby set aside. The petitioner should be reinstated into service. Liberty is, however, given to the respondent to initiate a trial by force court.
okay, so let's look at 51, Section 51 of the 1992 Act. Of what act? What is this act? That is the Indo-Tibetan Border Force Police Force Act 1992. This court, a coordinate bench of this court, observed that he should have been removed under Section 51, not 20 of the rules. So, do we have the rules here?
Yes,
The Act?
I have.
ITBP Act. What does Section 51 say? Let's see. These are the punishments. Okay, various punishments. Where removals from service may be there. Stoppage allowance, dismissal from service. M is dismissal from service. So the observation of the coordinate bench is that the removal or dismissal of service should have been done under section 51 of the Act. Okay, but in the termination order, it was made under 22 of the rules. So let's see the 22 of the rules. We just try and understand what's going on. Okay. Twenty is on account of misconduct.
Yes.
Anyways. I think we have got the picture. Yes, so.
My lord, my argument will be, my lord, only confined to the few issues, my lord. And my lord, this is a case of, my lord, no case. Exactly, my lord. And my lord, if lordship see the impugn order, my lord, normally, my lord, in the ITBP or any organizations of the force, my lord, the employees are not being removed normally, my lord. After, my lord, the exhausted the provisions and in the NDBers, they made to, my lord, to trace him out, my lord. These actions are taken, and the same thing is happening here, man. Happened here, man. My lord, may I take your lordships to the impugn order, my lord, which they have impugned.
Page.
In my affidavit in opposition, my lord, filed by the ITBP, my lord, respondent number 127, my lord.
Affidavit in opposition.
Filed by the ITBP, my lord. I'm appearing for the respondent number 127, and 8 and 9 are different respondents, my lord. They
So
are
who are 8 and 9?
8 and 9, my lord.
8 and 9
one is the officers in charge of the Kuch Bihar, my lord, West Bengal Police Station, my lord, and another is SP, my lord. Now the my lord, why they have been made as a party yet? Because, my lord, we have sent a letters to the even to the SP, even to the concerned police station to trace him out, my lord. That endeavors even we have taken, my lord.
Okay, to find him, to trace
To find
out.
him out, my lord.
So they're not required to appear today.
My lord,
We have served twice, but later the honorable judge said that leave them. So
Okay, not required.
Yes.
now, my lord, annexure 5, page number 24, my affidavit, my lord, filed by the ITBP. My lord, first affidavit, page number 24 is the Hindi language.
version, yes,
My lord,
Hindi
translated
language.
copy is 26, my lord. May I read, my lord. By reading,
Yes.
my lord, this entire things, my lord, everything will be clear, my lord.
Hmm.
The order dated, my lord, this was passed on 15 April 2014. Order the regiment number so and so constable oblique GD requid Rajiv Charkar, a company of Port BN ITBP police is absenting from his duty at Port BN ITBP police campus since 15/6/2013 afternoon. Without permissions of oblique intimations to the competent authority. AFI regarding the absence of the above individuals from the BSQ battalion headquarters has been launched at police stations Dirang, Arunachal Pradesh on 18 June 2013, and the individual was directed to report on his duty on at Port Bien, the headquarters. By this office telegram number so and so dated 25/6/2013, but individual has not yet joined his the arrivals at Fort Bien headquarters, and which is a punishable offense under section 21A of the ITBP Police Act 1992. The superintendent of police district, Kuch Bihar, West Bengal, was also requested to apprehend and hand over the above individuals to commandants of Fort BN ITBP police by this office letter number dated so and so with copy to SHO, the police stations, Boriarhat district, Kuch Bihar, West Bengal. But the concerned police did not succeed in handing over the said individuals, and nor any reply has been received so far. In view of the above facts, a court inquiry was constituted by the commandant so and so over so and so dated 12/9/2013. On the basis of the report and the recommendations of the inquiry, court of inquiry, the individual was declared a deserter, sorry. Finally declared deserter since 15/6/2013 by the competent authority by this office order number so and so dated 1/11/2013. And the copy of the same was sent to the permanent address of the individual straw registered post. They are denying them that they have not received anything. We have received. After declaring the above individual deserter, a so-cause notice was served to the individuals by letter number so and so dated, in which the individual was directed to reforms on duty and was given opportunity to appear at this battalion headquarters, Dirang, the West Kamen district, Arunachal Pradesh, and to keep his defense within the period of 30 days. But in reply to this notice, the individuals neither given his arrivals at the battalion headquarters nor to keep his defense. Apart from this, by this office later number so and so dated 4th February 2014, a notice for publishing in leading newspapers of the individual, the hometown, was sent to the assistant media executives directors of advertising and visual publicity, Susna Bhavan, the CGO complex, the page 4, Lodi Road, New Delhi. 3, in which the individual was directed to report to his duty and to appear at the battalion headquarters, Dirang, West Kamen district of Arunachal Pradesh, and to give his defense in black and white within the period of 15 days of publishing the notice in the newspaper. It was also informed that if he fails to report on his duties and to keep his defense, then so taking an expert defense on the disciplinary case made against him, so he will be removed from the service. But the above individual has not reported on his duty and not yet kept his defense. Next, please, Madam. It is clear from the above facts that the said individual has given many opportunities to remain in service, but it seems that the above individual is not willing to serve further in ITBP police force. Therefore, the exercising the power confers as per the provisions that contains in the Rule 20, read with Rule 17 of the ITBP Rules to 1994 by the undersigned. The regimental number so and so, Constable of the GD, Liquid Rajiv Charkar, a company of the Port B and ITB Police, is hereby removed from service with effect from the 14th 4/2014, and from this date he is struck off from the fostered strength of the force and this battalion. The absent period of the above individual from 15 June 2013 to 15/4/2014, total 304 days, are treated as dies known for all purpose. The personal details of the regiment is so and so, so and so. Now, by reading of this impute order, everything has been reflected. Now, several individual the endeavors were made to trace him out, even sending a FIR to the concerned police station. But after failings all efforts and the made endeavors of the respondent department, finally this order termination order has been passed. So therefore, it is not the case that the petitioner have not been given any opportunity to submit his defense, Now the petitioner is not denying this particular event that the copy has not been sent to the police station. He has not received even the newspaper publication. He has not got. So therefore, in the post, normally the employees are not being terminated because this is the petitioner is a GD, means he can be for the appointed for combating purpose, my lord.
Hmm.
So therefore, one has to be physically fit. Now, my lord, the termination order, as lordship has seen in the year 2014. By now, my lord, we are in 2004 to 24. My lord, even if the petitioner is, my lord, reinstated, my lord, there is no, my lord, chances of, my lord, the physical position and other things, my lord. So therefore, my lord, that is the, my lord, another aspect. And
No,
the, my lord,
this is wait issued by the commandant. isn't
commandant,
it?
my lord.
Now, is there a provision where you can appeal against this order? Not in
Actually,
the court, but is there appellant court?
yes, he have appealed in DIG,
DIG.
Tejpur.
Hmm.
So there they just given the excuse that he haven't appealed within time period. Limitation period have closed and they haven't give any other.
When did he apply for appeal against this order?
Since
When's
he
it?
was not aware of the appeal provision, so he have applied it in 2021. Before that, he went to uh, West Bengal High Court because he was not aware of the jurisdiction, all those things. So
Hmm.
he went to West Bengal High Court in 2016.
Hmm.
So after that, due to of lack of jurisdiction, he have sent back to this Guwahati High Court. He filed writ in 2016 again here in Itanagar High Court.
Hmm.
Here also lack of jurisdiction, he have sent back to the administrative tribunal Guwahati,
Hmm.
but he have told that the ITBP are not dealt in administrative tribunals, so he have sent back again to Itanagar High Court. So he have came here back again, he filed the review petition, and from here he have got to know that he have to file the appeal to the DIG Tejpur. So there he have filed in 2021. So from there his appeal was dismissed for time limit, only the limitation period and nothing else they have said in that order of the DIG. In
So
appeal.
you didn't appeal against the order of the DIG?
It's we are challenging here in the
The order of the DIG?
Yes, Your Lordship.
You are challenging the order of the DIG, which rejected your appeal on the
Yes.
grounds that it is barred by limitation.
Yes.
Is that it? Then come to that.
Actually, we didn't much given a strength because in the deserter order and termination order itself is like there are illegality and arbitrariness. So we are challenging that.
So you should challenge again regarding that to the appellate authority.
Yes.
Now, the appellate authority did not dismiss your challenge on merits.
Yes.
But on the grounds of limitation, barred by
yes.
limitation.
Yes.
So if you are unhappy with it being barred by limitation,
Yes.
then you should challenge that order first.
Yeah, Your Lordship, actually, we
Then
thought.
if we say that this order saying that it's barred by limitation is
Yes.
unreasonable because we have to give you reasons as to why you were delayed, then it is the appellate authority who has to first decide.
Yes.
It's not been decided on merits. So
Yes.
how can we jump straight away to the deserter when there's an appellate authority, isn't it?
Yes, my lord.
But Your Ladyship,
Where's the order
And
saying that it's barred by limitation? I'm just trying to.
It's in page number 100.
Page number 100?
Yes.
So whether the is the reasonableness of the termination order has not been considered, it appears, by the appellate authority. Where's the reasoning given by the appellate authority? Was it this thing decided on merits? Let's see.
Yes, it's in for
Come
merits.
to that
It's
first, huh? Yes.
Yes.
Get your points right first, isn't it?
Yes. Your Lordship.
2021, isn't it?
Yes.
So, did the appellate authority discuss the matter on merits? Then we can consider. If it's not, you're saying that it's barred by limitation. If that is the point, then you'll have to challenge that order. If it's not that and it's been dismissed based on, after discussing the merits, then we can consider.
Even for merits also, the appellate authority have given some lines, but more on the limitation. It's for merits, it's in para 4.
Para 4.
Yes.
Hmm.
They have mentioned some facts that they have sent some letters to him.
So certain facts have been discussed, isn't it? So read the operative part of the order by the DIG.
It's from para 2 only. They have mentioned all the things, or the facts, how he have dismissed.
So it's decided on merits,
Yes.
not on limitation.
Limitation alone.
It's not on limitation.
Yes,
So
yeah.
this is in your favor.
Yes, even
Present here, huh? Yes, so it's been decided on this thing, merits, it appears, long order. Isn't it?
yes,
So now we can consider. I was thinking if it's on limitation, then we cannot consider. But looking at the order, it's not on limitation, it's grounds of limitation, but it's on merits have been discussed. Okay. So anything else? But
your
only thing is, where's the termination order page?
sorry, Your Lordship.
Termination order in your petition is page
Termination is in page 65.
65.
Your Lordship, I just want to make one.
Wait,
here.
some clarifications we need. No, page
Yes.
65. This is 15/04/2014. This is the termination order received by you.
Yes.
Now, the letter which we're just reading, what is that in your affidavit in opposition?
Your Ladyship, it's in page number 26. Which,
26.
yes. 26 of affidavit. I just want to make one little submission.
Now, how come they're different?
Yeah, Your Ladyship mentioning which letter?
Now, page 65 of your writ petition order dated 15/05 is 15/04/2014. This is the order translation. Or maybe the translation is made very short.
Yes, translation is in before.
Yeah, translation is not correct. Okay,
Yes.
because the translated copy and the translated copy given by the respondent is very different. So I was thinking it's a different order.
Yes.
So your translation is very short without giving all the facts. Now, do you have the translated copy 26? This is the full translation of the affidavit in opposition.
Yes, I didn't receive this. I didn't receive.
You should have this
26.
because here, then you can reply to the points given in the
65, yes,
translated
yes.
copy. Just look at 26, a copy was received. Because what you've mentioned in page 65 of your writ petition is very simple. Okay, you are basing your writ petition, your grievance on this page 65. While here in page 26, it's
Yes.
more detailed, more different. So the reasoning giving there, you have to address to that.
Yes, Your Lordship, I don't have this one. I guess I got other one, original one somewhere else now. Because we filed thrice this petition, so in that journey, we lost somewhere the.
See, this is a full detail.
Yes, Your Lordship.
When they're giving their reasons.
Yes.
Now you have to address the reasons given by them
Yes, Your Lordship.
in page 26.
Yes.
Isn't it?
Mm.
So here, what I'm trying to find out is that the termination letter is due to the unexplained absence, your absence,
Yes.
between a certain period.
Well,
Okay. So you have to explain between that period and not the period prior to that.
Yes.
Because prior to that, your hospitalization, all that is not concerning them. They are giving your letter, termination letter is with regards to a period of 300 something days, almost 1 year, but the period which they have mentioned and the explanation given to you is before the period mentioned by them in their termination letter.
Yes, Your Worship.
So your submissions are not tallying. I'm not being able to understand.
Your Lordship, because the show cause for deserter
What
order.
is the order? Huh?
For deserter order and show cause notice, he received after the termination order.
So this termination order, but when you come to the court, you must
Yes.
have seen this termination order. But the termination order which you have filed in your writ
Yes,
petition
it's
is different
translate.
from the actual original termination order,
Yes, Your Lordship.
isn't it?
It's
So you
transfer.
have to file your writ petition based on what is given in your termination order, and in the termination order.
Actually, Your Ladyship, if you may come to page number, it's 63.
And my lord, the same, my lord, the
Wait, where is the period mentioned in the termination order? Which line? I'm just trying to find out. That was what I was a bit
In affidavit, it's mentioned 304 days, but in my, it's not there.
So the period, okay, the period for your absence has been mentioned in your termination
Yes.
order. So you have to explain why you were absent within that time, not prior to that you were sick and all that. That is not mentioned here, no?
yes, specifically given, my lord.
Yes,
Oh.
Together with-
for those days, I have already mentioned the medical documents which I have given here, and two representation letters which I have submitted to
Yeah,
them.
so let's look at that. So let's come to page 26 of the, now it's lunchtime. We can continue later
Yes,
at 2. Let's get the picture clear.
yes.
Okay, because you have given a lot of details. And in your writ petition, you have enclosed a termination order,
Yes.
which is actually not the correct copy of the term. You should have enclosed this.
Yes.
Translated as very skimsy, and it is not really accurate. Isn't it?
Yes.
Anyways, if you do not have any more submissions, we'll
Yes.
leave it. We'll make it a CAB. I'll have a look at this and then
My lord.
try.
My submission before your lordship is, my lord, on several occasions, my lord, this matter has been heard. And my lord, on some other ground, my lord, matter has been adjourned, my lord. Now.
Oh, it has been heard before.
Yes, Your
So therefore, my
Due
lord,
to
may I present, my
sir
lord,
sir was not prepared, so I had to
no, my
make
lord,
submission
it
again.
was not the exact the situation, my lord. On several occasions, my lord. So therefore, my lord, my submission is, my lord, this matter may be, my lord, disposed of.
But you're leaving the homework to the court to study and see what is going
My
on,
lord.
isn't it? So I want to
Affidavit is very clear and the rare pleaded case is very clear.
wait, huh?
Yes.
Just come to page 26 of your
Affidavit.
determination order. We have
Yes,
to
ma'am.
study this carefully.
Yes, ma'am.
Now, in the termination order, there was a period mentioned.
Yes, ma'am.
Where's that? I'm not finding it.
My
straight
lord,
away.
period of absence, my lord, is.
It's in last 27.
My
It's
lord, page number
304 days.
27.
Last line, 304 days.
Yes, from
Is here by
15/6/2030 to 15/4/2014, isn't it?
Yes, ma'am.
Your Ladyship,
Yes.
this is also true that
15/6/2013, yes.
this is also true that he haven't received any payment from the time he left the his unit. So
Where's that? Nothing. This thing.
So
No
they're
payment. Have you addressed to that, whether he has received payment or not? See,
Madam,
your submission is was in Ribery Hospital on 28 to 2012. That is not concerning this. When did you apply for your leave, 6 months leave?
No,
Which
Your
was not
Lordship,
considered.
if it's come to intention that whether he wants to join because of his willfulness, he left the
Yes.
unit or not. If it's willfulness that he left, then he should have been received the salary and he should have been stayed at home. But because he was sick, so he couldn't do anything. So,
So when you say he was sick, you show me that he was sick from 15/06/2013. Because all your previous letters, it is 15/6, so dissertation letter, let's see. So you have to address to this period for which you are terminated, isn't it?
yes, since he was in apprehension that since already the if your ladyship may
What
come.
I'm trying to understand is all your medical letters, which you have showed me in the hospital, this is 2012. 2012, we're not bothered. Okay, 10/4/2012, he joined. We are not bothered with that. Okay, then I think at one time, then you had asked for leave on 26/02/2013. And 6 months. Okay, so if you had asked for 6 months leave, 26 months will expire on 26/08/2013. And you were absent from 15/06/2013.
304 days, ma'am.
And in between, the police came to his home and he have given the documents, medical documents and signature on the blank letter. So he was in comprehension that they have already submitted
Signature on a blank letter?
Yeah, yes,
Where,
paper.
where?
On 15/07/2013, two West Bengal police came to his residence. And even in this termination order also they have mentioned, but the concerned police didn't succeed in handing over the said individuals and nor any reply has been received. There is also, they have,
Very easy to say.
no, your ladyship, they just terminated him in vague
Let-
terms that they haven't received.
Last officer,
him.
my lord, I have placed one judgment of our own High Court wherein, my lord, same case, same nature, my lord, it is also the same ITVP where deserter case has been, my lord, decided, my lord. In half,
Okay,
my
give the order
my lord, I have given the copy, my lord. It must be on the record, my lord.
in the record.
Read petition number 300 of 753 of 2022. And the
Dated.
party's name are Simintang Hofki.
Petitioner.
Read petition.
Okay, this is 07/09/2023.
Correct,
Okay, this is.
ordered by his lordship schematic.
Oh,
This is same case, my lord.
same case means similar.
Similar, my lord.
Ah,
Similar,
it cannot be the same
yes, ma'am.
because it cannot come again. Huh.
Yes.
Okay, we'll make it a CAV, heard Miss So-and-so.
My lord.
Because along with Mr. So-and-so, okay. We'll make it a CAV.
Deeply obliged, my lord.